My name is Tim Hayes. I'm the Executive Director of AIR CRE, and I want to thank all of you for attending today's town hall meeting featuring Brian Mashion. This is the third town hall AIR CRE has hosted during the past few weeks, and we will be hosting additional sessions in the coming weeks. We will be emailing you information regarding those upcoming town halls, so be on the lookout for those emails. Before I introduce Brian, I want to mention a few things, and I mentioned this already, but in case you joined late, the session is being recorded. We will make those, the recording for today is available on Monday on our website. You will receive an email on Monday morning letting you know that it's been posted. Also, the other sessions that we've done with Lee Dressy and Josh Geller from Greenberg Glesker that were done 2 weeks ago and last week, they are already on our website. So if you go to our AIRCRE.com, click on education, you'll see those two videos. You can click those and watch them or listen to them. And then you can share that link with your colleagues and your clients. Like we've done with the previous two town halls, when we sent out the invitations, we asked you if you wanted to send in questions. Those questions have been compiled, and Brian will either address those during his presentation with the information that he's going to be sharing today, or when we get finished, we will go through each of those questions. You also can use the chat box to submit questions. I will be monitoring that while Brian is speaking, and then we will do our best to get to those as well. Brian's presentation is between 35 and 40 minutes. So once he finishes, we will get to the questions. Also, the emails that we sent you notifying you of this town hall included a link to the single tenant net lease. And many of Brian's comments today, the AIR's, the AIR-CRE's single tenant net lease, and many of Brian's comments will be referring to that lease. So if you want to, you can go back to that, the invitations we sent you, scroll down, click on that, and it will open up that lease from our website, so you can follow along. The topics that Brian will be covering today, Steph, if you can put them up there on the screen for me, please. He's going to be covering AIR CRE leases and how they address coronavirus issues. The first topic will be beyond force majeure, parties' rights and remedies. Number 2, does legal order for businesses to close mean tenants don't have to pay rent? Number 3, what are the remedies of landlords in collecting rent? And number 4, what are the consequences of non-payment of rent under the leases? Before I introduce Brian, I also want to mention that, as everyone has probably experienced and has been reading about, there's talk that there will be many lawsuits filed as a result of what has gone on with the shelter in place and the coronavirus situation. Of course, we're hoping that the information that our attorneys have been sharing with you in the last 3 weeks, including Brian today, will keep you, will keep your clients, will keep your colleagues out of legal situations. But we've also been reading that a good alternative to that is mediation. And with that in mind, in the next few weeks, the AIR will be rolling out a mediation service. Given our position in the market and our 60 years experience in commercial real estate, we feel we're uniquely qualified to offer that service. So keep it in mind, you'll get more information about it as we go and as we get closer to rolling out. And if there's any way that we can help you in a situation where mediation might be appropriate, we're here to help. So now to introduce Brian. Our presenter today really needs, Brian needs no introduction. He's been in the commercial real estate, he's been a commercial real estate attorney for the past 30 years. I'm always amazed at how many people I speak to when I mention who our attorney is for our contracts already know Brian. For the past 3 years, I've had the pleasure of working with him as he's taken on the role of legal counsel to AIR's contracts committee. In this capacity, he's responsible for reviewing and modifying all the AIR CRE contracts and making sure that they are update and current, especially with commercial real estate law. He's also responsible and is the chief writer of all new agreements. And as you guys know, in the past couple of weeks, we have rolled out two amendments, one for purchase, sale, and escrow instructions that allows you to modify a purchase and sale agreement in light of coronavirus. And then the other one we rolled out was the base rent reduction or deferral amendment, And so those are both of those are available now on our through our contracts app. So if you need to access those, you can do it through there. Brian earned both his undergraduate degree and his law degree from UCLA, where of course he was the editor of the UCLA Law Review. Brian has 2 grown children who sound very impressive. One is attending Harvard Law School. His son is attending Harvard Law School, and his daughter is a junior at USC. And not to be outdone, Brian's wife, Hala, is an accomplished artist and musical composer and the owner of Mass Gallery in downtown LA. And with that, Counselor, take it away.
All right, thanks very much, Tim. So we're all experiencing this terrible economic downturn because of all the business closures due to the coronavirus pandemic. And I have been getting a lot of calls, and the AIR STIP has been getting a lot of inquiries from everybody on both sides, the landlords and tenants. The tenants who've stopped paying rent now, and they're looking for new ways or additional ways to stop paying rent while they're closed. And the landlords are on the other side. Conversely, they want assurances that the tenants remain liable and obligated to pay the rent. So let's focus on the AIR leases, and a lot of the questions, and a lot of the topics that I'm going to talk about are from the hotline that I answer general questions about the AIR contract. We're going to focus on the AIR CRE leases, and my practice is in California and in Los Angeles in particular, so I'm focusing on those jurisdictions, although we do publish our contracts in other states. You got to keep in mind that the outcome in any case depends on the facts, the specific and unique facts on the lease involved, and the language and each needs of the parties. Let's get into, before we get into going beyond force majeure, let's just do what is force majeure. And that's typically what people refer to as acts of God. It's generally an event that interferes with performance of a contract. It has to be unforeseeable, it has to be uncontrollable, and unpreventable. So despite efforts to comply. So the AIR CRE leases do not contain a force majeure clause, as a lot of you already know. I've answered a lot of questions and so on as the AIR staff about that. Our leases do not abate rent in case there is a force majeure. And that's with the exception of fire, casualty, other kinds of damage and destruction that are covered under Section 9 of the leases, and also with the exception of condemnation, which is covered under paragraph 14 of the leases. So the AIR CRE leases do require that the rent be paid still during this pandemic when it's due, but that is not the end of the inquiry here, because as I'll talk about it later, there are other legal theories that come into play in this situation. But one of the common misconceptions is that if you did have a force majeure clause, somehow that would automatically abate the rent and the tenant wouldn't have to pay the rent. The fact is that the typical force majeure provision that is in a lease specifically says, look, if these things happen, you still, tenant, have to pay rent. So even if the AIR leases did include a force majeure clause, if the clause was the typical one, it would specifically provide that the tenant continues to pay rent. Force majeure clauses are also very strictly construed by the courts. You have to meet all the requirements of the force majeure provision. No, go back a slide, we're not there yet. So you must meet all the requirements, and the event must be one of the causes that's supposed to be covered in the force majeure provision. So the typical events, other than fire, which I just mentioned, is war, terrorism, labor, strikes, material shortages, government acts. Until now, usually viral diseases and biological epidemics were not included, and whether it will be construed, whether COVID-19 or coronavirus pandemic will be considered to be included in one of the force majeure enumerated events depends on how the courts interpret the force majeure events. And we already have a case out of Supreme Court of Pennsylvania, Friends of DeVito versus Wolf. It was decided April 13 this year, 2020. It does not deal with the issue of force majeure in a lease context. This decision came about because the authority of Governor Tom Wolf's to issue an executive order closing non-life sustaining businesses was challenged in court. And the Supreme Court, the Pennsylvania Supreme Court, characterized COVID-19 pandemic as, quote, a natural disaster and a catastrophe of massive proportions. Now, this characterization by the Pennsylvania Supreme Court, obviously it's not binding on the California Supreme Courts, but this kind of characterizations that we're going to have coming down from all sorts of courts in many, many different states, they will be used by parties to try to invoke arguments that the COVID-19 pandemic constitutes a force majeure event. And if it's a natural disaster, and that is one of the events that's covered in your particular force majeure provision, then you may be able to rely on the force majeure provision if it doesn't specifically say, no, you still don't get rent abatement. So the typical thing that happens when a force majeure event happens, like I said, the rent doesn't get abated, but what the remedy is to extend the time for performance to the extent that the party was prevented or delayed. So, for example, in paragraph 3.2 of our leases, that is paragraph deals with what happens if the landlord is delayed in delivery of possession of the premises. That specifically says that if the lease commencement date is delayed, then the tenant's free rent gets delayed until the landlord delivers possession. So that's kind of built into the contract already. So if the landlord is delayed due to material shortages, some kind of inability to get inspections done properly and quickly, and if there's a delay in completion of construction, so the tenant is protected and the landlord is protected there as well, because the completion date automatically gets extended. But paragraph 3.2 of our contracts provide that specific termination rights. And this paragraph 3.2 gets triggered because of typically two events. One is there's a completion of construction that needs to be done. And the other one is somebody's in possession of the space that needs to be removed. Therefore, an eviction action or something needs to be done to get the possession back from the current occupant. Paragraph 3.2 specifically says the landlord is supposed to use commercially reasonable efforts to recover possession. And there are two different cancellation triggers in 3.2. This is in the single tenant net lease form that Tim mentioned I'm going to be using. And most of the paragraphs that I'm referring to are the same in all the AIR CRE leases. So again, it's the single tenant net lease form, and 3.2 is the same in all the leases. There is a first trigger that says if the landlord doesn't deliver the space to the tenant within 60 days after the commencement date, then the tenant has a 10-day window within which to cancel the lease. So that's the first trigger. The second trigger is if the tenant doesn't cancel within that 10-day period and the landlord still cannot deliver possession within 120 days, then the lease terminates unless the parties reach some other agreement. So if you're signing leases today, you really want to make sure you look at paragraph 3.2 and modify it as necessary if there is a tenant that needs to be removed and the landlord can't file an eviction action due to the moratorium on evictions, which I'll talk about more later, or there's construction that needs to be done that requires permitting and you can't submit a new permit application, or there's delays due to completion of inspections. You want to consider all that and modify paragraph 3.2 to make sure that it works for your particular situation. The other thing to consider, one other thing to consider is a lot of shopping center leases in particular, they have a continuous operation provision in them. The AIR leases, this is the shopping center, the shopping center multi-tenant net lease form in paragraph 6.1b as in boy, has a continuous operation covenant and actually has specific hours of operation. A lot of tenants have now been ordered to close. So if they do comply with the law and they do close, they are not considered to be in default. The other leases that the AIR publishes, besides the shopping center lease, do not have an operating covenant. They actually only provide in paragraph 13.1 that if the tenant vacates, the tenant is not in default as long as the tenant is carrying the required insurance and provides reasonable assurances to avoid vandalism. So there's no requirement that you be open and operating in the other leases other than the shopping center leases. So going back to the force majeure provision, our leases, while they don't nominate or specifically call a provision force majeure, we do have built-in force majeure extensions of the party's right to cure. Specifically, in paragraph 13.1E, that's the section that deals with the tenant's default for certain non-monetary defaults. And in paragraph 13.6, that deals with the landlord's default. These provisions both provide that there is an initial 30-day period after written notice to cure certain non-monetary defaults. But these provisions also specifically state that if this 30-day period is extended, if the nature of the default is such that more than 30 days are reasonably required, and if that's the case, the cure has to be started within the first 30-day period and thereafter diligently prosecuted to completion. So if there is some default other than payment of rent that is not able to be addressed because of COVID-19, the built-in extension of time should cover both parties, both the landlord and tenants similarly. So let's go beyond, let's go to the next slide and talk about what are the parties' rights and remedies beyond the force majeure provision of the lease. And I'd like to focus on one California statute in particular. It's California Civil Code 1511, Section 1. And this statute was enacted in the 1800s, so the language is not is kind of archaic, but I'll paraphrase it for you. Basically, this Civil Code section says that performance is excused, quote unquote excused, if performance is prevented or delayed by, quote, the operation of law, even though there may have been a stipulation that this shall not be an excuse. So what the statute is saying, even if your contract says that your delay due to compliance with operation of law is not allowed, that contract provision is overwritten by this statute. So the law, in effect, trumps whatever the contract language says. So this Civil Code section 1511 is going to apply even if the contract provides that operation of law doesn't excuse performance. And it overrides the lease provision that specifically provides otherwise. Civil Code 1511 does say that the agreement can require written notice within a reasonable time of the event. So there are cases that say if that was in there and the parties failed to comply, there are consequences for failing to comply with the notice provision. So Section 1511, it's a good question. I mean, Tim talked about how we published a new amendment to the leases to deal with the base rent reduction and base rent deferrals. And these amendments are being, I understand, I'm doing a lot of them myself today for both landlords and tenants. And we're signing these amendments today to reduce or abate, to reduce or defer rent. And a good question is, what is the impact of 1511 on these amendments? Because the amendment that we prepared for the AIR CRE says that the tenant waives the protections that are afforded to it by law due to the coronavirus pandemic. And the operation of law is one of those defenses that's available. Is the amendment enforceable even though the statute says you can't contract your way around the statute? There are no cases that I found in 1511 deals with the statute, but I think an argument that a landlord can make that is that when we signed this amendment, the moratorium was in place, and this is not a change in law. Rather, this was the law. Everybody understood what they were doing fully well, that some tenants are closed, some tenants are barely making it, being partially open. So can the tenant keep coming back to the landlord and asking for more and more rent reduction or more rent abatement, even if the parties have already signed an amendment? I think that's an open question. We don't know for sure, but I believe that since the tenant and landlord are fully aware of the coronavirus pandemic existing when the amendment is signed, it is something that the parties accounted for and was part of their mutual understanding. So I want to talk about some of these cases that have interpreted 1511 because I believe it's going to be helpful for your understanding. These cases basically say making performance unprofitable, more difficult or expensive generally does not does not excuse performance. And the performance is excused when the law prohibits the thing that you agreed to do. So the first cases that there's three cases I want to talk about. Lloyd versus Murphy. These are all our cases that were decided after World War II, dealing with what happened to the government orders that came down during World War II. So during World War II, government halted manufacturing of new automobiles, and the new car sales made up 80% of this car dealer's business. And he didn't pay rent, and the landlord sued, and the tenant said, look, I can't make new car sales, and I want to get out of my lease. And the court said, that's not an excuse for your obligation under the lease, because you could still sell used cars, you could sell cars to military workers, and to escape contract due to government order, the order must have rendered carrying the business, quote, impossible. So that's a pretty high threshold to be able to get out of a contract under 1511. There's another case, Davidson versus Goldstein. This lease was signed before World War II. The United States went and entered World War II. The lease provided that the tenant can use the premises for selling new and used tires, fixing and retreading tires, as well as recharging and renting batteries. The tenant sought to terminate the lease because of the limitations on tire sales that happened during World War II. And the court said, no, a change in law which merely restricts but does not wholly prohibit the conduct of the business does not release the tenant from the obligation to pay rent. And the court made 3 points. One is that the property that was described in the lease was adapted and suitable for all purposes. Second point was that the lease did not limit uses. And the third point was the tenant was able to continue selling some of the tires to certain individuals and also continue its batteries business. The third case is Rose versus Long. This case was almost a self-inflicted wound because the tenant leased a brick and steel building for storage warehouse in Orange County. The lease stated the premises was not in a first-class repair and tenant took the space as is. The landlord was not obligated to make any repairs. The building department put a notice on the premises saying it's unsafe for human occupancy and it's unlawful for any person to occupy. Tenant stopped paying rent, tried to abandon the premises, saying the lease was terminated by operation of Civil Code 1511, and the court held that the tenant was still liable for rent and noted that, one, the lease made the tenant responsible for repairs, so the tenant really couldn't benefit for not doing the repairs, getting cited by the government to correct it, and then say, oh, I can't use the space because it's not up to code. The tenant itself testified that the space wasn't unsafe for its purposes, and the tenant didn't challenge the right to occupy the building. So the court held that no, the tenant was still liable. So we see the operation of law excuse under Civil Code 1511 depends on the use, the property, and the legal order. So Governor Newsom basically said, close your businesses, right? I'm sorry, Governor Newsom ordered stay at home, then there's social distancing, keep social distancing. Mayor Garcetti's ordered bars to be closed, nightclubs, movie theaters, live performance avenues, bowling alleys, et cetera, et cetera. So why are those cases important for us to pay attention to and for your consideration when you're looking at your clients who are saying, hey, do I pay rent? Do I not pay rent? Can I rely on 1511? It's a question of where you ordered to close. And you see those cases that I mentioned, some of them could still use the business, and the closure by operation of law has to be a total closure. So the orders that we have today basically say, you have to stop operating, cease operating. Some restaurants are still able to operate. They do takeout, delivery. Domino's Pizza, for example, does delivery only. There's drive-throughs. There's online pickup. Starbucks does online pickup. So there's still some residual uses that tenants can make. And I think in those situations, it's going to be difficult for a tenant to argue under 1511. The government order should excuse them from being able to pay rent. The Mayor Garcetti's order specifically said everybody stay home and ordered some businesses to be closed, but then made an exception for the closure order. It said for non-essential businesses, they're permitted to conduct minimum basic operations including inventory, security, et cetera, and activities that are designed to maximize the ability for its employees to work remotely from their homes. So you don't have 100% closure. Rather, you do have the exception for being able to come into an office building, like I am in my office right now, to help your other employees work remotely. So this is very important to consider when your clients or your business is closed and you're saying, can I use 1511? It has to be, I believe, a pretty high threshold of not being able to use the space at all. The other thing to consider is how long is this closure? Right now, we don't know how long it's going to be. It could be 3 months, 6 months, 9 months. It is going to be over at some point. And the war also ended. So does the fact that it's indeterminate now make a difference, just like the war was indeterminate when it was occurring? The other factor that these cases talked about is that you couldn't use the space for something else. And paragraph 6.1 of the AIR CRE leases permit the tenant to change the use to, quote, any other legal use which is reasonably comparable to the agreed use. So the tenant has the ability to change the use with the landlord, with the landlord's consent even. The leases provide paragraph 6.1 that the tenant can come and ask to modify the agreed use with the landlord's consent, and the consent can't be unreasonably withheld so long as it doesn't impair the structural integrity of the improvements or the mechanical or electrical systems, and is not significantly more burdensome. So you don't have a very inflexible use clause. Rather, it allows you to use it for comparable uses, even allows you to change it. So this argument goes to, can I use the place for something else that's not ordered to be closed? Finally, we got to look at, well, what is excused? The 1511 says your performance is excused. Well, the order says you have to cease operations. It does. It's actually, the orders specifically say rent is not abated. Tenants still remain liable to pay rent. So is the excuse of payment of rent for the duration of the COVID-19, or is it for 3 months, 4 months, or we don't know. Also, the statute says the excuse is, quote, to the extent to which they operate. So will the rent reduction or deferral be prorated based on the loss of income that the tenant suffered due to the coronavirus pandemic? Some tenants may try to cancel the whole lease, which probably will require an impossibility of use or something that is a much higher threshold. I'm not even sure if you can get a partial rent abatement or deferral. We haven't seen that in any of the cases that interpreted 1511. One other question that's on my mind is, can 1511 be used only by the tenant as a shield to non-payment of rent, or can a landlord use it to terminate a below market lease? Can the landlord come and say, okay, well, this tenant was ordered to close. I want to cancel this lease and get them out of here because it's really a below market lease. So the distinction being between ordered to close and voluntarily closing on a prophylactic basis is a very important fact to keep in mind. Arguably, to close by Garcetti's March 19, 2020 stay-at-home order impacts the financial losses and profitability of the business. It's not the health concerns. So whether you meet the requirements of 1511 is going to remain based on how the courts interpret 1511. There are lots of other legal theories that are going to be used for excusing or defending performance. I'm just going to mention them. I don't think we're going to go into it. It ends up being too legal of a discussion. The first one is frustration of purpose. If the property is leased to a tenant for a particular use and the tenant is not able to use it, that should be able to allow the tenant to cancel the contract. Impossibility or impracticability, supervening events, failure of condition, prevention of performance, unconscionability, lack of consideration. In other words, I agreed to pay you rent for the space. I'm not able to use the space. I don't want to pay rent. So I think lack of consideration is going to be coupled with a argument under Civil Code 1511 to get rent abatement. All right, let's move on to paragraph 8.4. That's the last bullet on the slide that's on the screen. Paragraph 8.4 of our leases require the tenants to carry business interruption insurance, and this insurance is intended to cover loss of income and the tenant incurring extra expenses. Our leases do not dictate the type of perils that the tenant is required to insure under its business interruption insurance or to specify the amount. Rather, the tenant is left to decide the coverage. Our leases provide for the tenant to decide to get coverage for, quote, all perils commonly insured against by prudent lessees in the business of lessee or attributable to prevention of access to the premises as a result of such perils. So that was left up to the tenant to decide. Obviously, the premium is going to be more if there are more coverages that a tenant that gets insurance for. Coronavirus may not be covered by business interruption insurance. I think most people that I've talked to, there's a specific exclusion. And whether landlords will now require the tenants to get biological or viral disease infection pandemics is not known, because I think it's going to depend on, first, is it going to be available and how expensive it's going to be. And right now, I think there are business owners getting ready to sue insurance companies. They're arguing that they lost money, not because of the coronavirus, but because of the government order. So the exclusion for viral and bacterial infections should not be applicable. And you know that's going to get litigated unless the federal government weighs in and funnels money through the insurance companies to these businesses. So the stay on eviction, let's go to the next slide, which is talks about landlord's remedies, if there is any today. We all know there's a stay on evictions, and the stay on evictions does not abate rent. The orders specifically say the rent is still due. On March 16, 2020, Governor Newsom issued Order N-2820, which limits issuance of summons in unlawful detainer property cases. And the stay is only if the basis for eviction is non-payment of rent, it arises out of a substantial decrease in household or business income, and is caused by the COVID-19 pandemic, and it's documented. And the order specifically says, quote, nothing in this order shall relieve a tenant of the obligation to pay rent, nor restrict the landlord's ability to recover rent due. So there was a Judicial Council emergency ruling on April 6th, and they said they will not issue any summons unless there is, the case is necessary to protect health and safety. And there's not that many of those. Most of them are basically for non-payment of rent. And any trial that was in an unlawful detainer as of 6 was continued for 60 days. You should be aware that the LA ordinance specifically excludes tenants who are, quote, multinational company, a publicly traded company, or a company that employs more than 500 employees from receiving the benefits of unlawful detainer moratorium. So those tenants cannot rely on the moratorium on unlawful detainer. Rather, they're going to be responsible for paying the rent, and they can be evicted. So what do you do today? Do you give a 3-day notice, assuming that the tenant is not one of the exempt ones? Do you give a 3-day notice now, or do you, what do you do? I've had basically clients take all three approaches. There are some that are very proactive, and they approach the tenants and they make a deal, either rent deferral or rent reduction, and have the tenant pay part of the rent. Usually operating expenses are typically covered. The tenants are required to pay the CAMs, and the amendment that we prepared only will abate or defer base rent. It doesn't defer or reduce the common area expenses. The rationale was the landlord needs those monies paid by the tenants to be able to cover the property's ongoing operating expenses. So the landlord shouldn't be further burdened upon by not getting those amounts paid by the tenant. Even if you were able to evict a tenant, one of the conversations I have with my clients is, well, what are you going to do? Let's say you got the space back today. Who are you going to lease it to? Who is really going to step up today and say, I want to lease that space, unless you're really willing to take a cut in your rent and anybody who's going to be leasing space today is looking to make a very good deal and maybe take advantage of the situation, or they have a real need to move. So on the other side of the spectrum, if you have a tenant, if you're a landlord, you have a tenant who has a below market rent, or you have a lease that's very favorable to the tenant, this could be a strategic moment in time where the tenant is not paying rent or can't pay rent, and then the landlord can move to, this could be an opening for the landlord to move for terminating, or at least opening up the negotiations for taking away valuable options or exclusives, et cetera. And I'll talk about options in a little bit more. So if you noticed, I mentioned that the moratorium is on issuance of the summons, not on the filing of the complaint. The courts have gone electronic, and you can actually still file complaints. You basically cannot get a summons issued on an unlawful detainer to be able to serve the summons and prosecute the unlawful detainer. So there may be a strategic reason for a landlord to serve a 3-day notice and file an unlawful detainer complaint, even knowing fully well that you can't prosecute it, because by serving the 3-day notice and the 3 days expires and then you file a complaint, the landlord has bolstered its argument that the lease is terminated. There's a bankruptcy case, Windmill Farms, where the court held that the lease isn't terminated until you've given the 3-day notice and the 3 days have expired without the tenant paying rent. And obviously going the further step of filing the actual complaint helps bolster that argument even further. So that may be a strategic act by a landlord to make sure that they can strengthen the argument that the lease is terminated once the dust settles and we're past this pandemic. But that may not be the end of it, because a tenant may be able to go back to the court and ask for relief from forfeiture under California Civil Codes Code of Civil Procedure 1179, which basically allows the tenant to go back to the court and throw himself at the mercy of the judge and say, don't terminate my lease. I want to stay. I don't want to lose my business. One other remedy that's available to landlords is not to file an unlawful detainer, but you can file a lawsuit to collect the rent that's due. We basically have two remedies in California, two major remedies. One is to file an eviction action, terminate the lease, and the other one is to keep the lease in effect and sue for the rent as it becomes due. That's under Civil Code 1951.4. So this allows the landlord to go ahead and sue the tenant now for the rent that is not being paid, but you're not trying to evict the tenant for non-payment of rent. And there's no moratorium on those types of lawsuits. One other option would be for a landlord to file an action for ejectment instead of an unlawful detainer. There's really no advantage to an ejectment action. Well, and let me say this, an ejectment action is not entitled to priority like an unlawful detainer. It's not a summary proceeding. You have to file you have to get 30-day summons, and it's not afforded any special preference over other cases. So in any event, I think whatever you decide to do, if you're trying to prosecute and enforce the lease, you have to be very careful in how you're going to be treated by the judges, because they're not going to look favorably on this. There is no moratorium on using security deposits, but be careful not to use a security deposit and try to backdoor it to get the serve the tenant for a 3-day notice to get the rent that way. You can apply to cash. If you have a letter of credit as a security deposit, there's no moratorium on that. As far as I know, you can go ahead and draw on that. If there's a personal guarantee, you can sue a personal guarantor. You can sue a guarantor for the liability under the guarantee. You can also try to get an attachment on the guarantor's assets if you want to be super aggressive. So let's go to the next, okay, the next bullet is, that's fine. Let's talk about paragraph. What are the possible consequences for non-payment of rent on a tenant? The first one is paragraph 13.3 of our leases, and I get a lot of calls on this one. This paragraph basically says, if the landlord has provided free rent, tenant improvement allowance, or other benefits to the tenant, that agreement is conditioned on tenant performing its obligations under the lease for the term of the lease. And if there is a breach, those provisions are no longer of any force or effect, and the tenant owes that money back. I have a situation right now where a tenant was provided $500,000 of credit to build out the space, and they defaulted, and they owe most of it back at this point. So that's a big lever that we've been using in the negotiations. So for you to be able to claim the benefit of 13.3 as a landlord, this is available after a breach. Our leases distinguish between a default and a breach. A default is a failure to do anything that's required by the lease. A breach is after notice and opportunity to cure has been given and expired. So if you want to invoke paragraph 13.3, you do have to give the notice of default. The other one to really consider from a tenant's perspective is non-payment of rent could end up causing the tenant to lose very valuable options. Under paragraph 39.4, options include options to extend or reduce the term of the lease, right of first refusal, right of first offer, options to purchase, right of first offer, or right of first refusal to purchase. So those can be very valuable rights that a tenant gets. And under 39.4 specifically says the tenant can't exercise an option, one, after a notice of default and until the default is cured. The second one is when any rent is unpaid, and in that situation, no notice need be given to the tenant. So the fact that the rent isn't paid is sufficient to suspend the tenant's ability to exercise the option. Or when tenant is in breach, that's after notice and opportunity to cure has been given. Finally, if the tenant has been given 3 or more notices of separate defaults, whether or not the defaults are cured during the 12-month period immediately preceding the exercise of the option. So from the tenant's perspective, it's very important that you pay very close attention to these provisions to make sure that you don't lose those valuable rights if you decide to not pay rent. Paragraph 39.4 further goes on to say that an option terminates and it's of no further force and effect if after the tenant exercises the option, the tenant fails to pay rent for a period of 30 days after it becomes due, and there's no necessity of landlord giving a notice in that situation. Or if the tenant commits a breach, again, a breach is after notice and opportunity to cure. So if you are planning to use paragraph 39.4 as a way to cancel or terminate any of the options as a landlord, you should be mindful that the tenants will certainly try and use COVID-19 as an excuse for not paying rent. And I think they will probably have a sympathetic ear with the judge if they want to argue that they shouldn't be more punished further by using these options. Let's talk about late charges. Paragraph 13.4, you can invoke late charges. Paragraph 13.5 requires interest be paid on past due amounts. You should check the local jurisdiction to make sure there's no restriction on imposition of late charges or charging interest. The Los Angeles ordinance does specifically say, quote, no owner shall charge interest or late fee on rent not paid under the provisions of this article. So this relates to commercial evictions. So make sure you check your local jurisdiction. And one thing that you have to keep in mind, there's so many layers of moratoriums and new regulations and stays being imposed on a federal, state, county, and city. So you really have to check your particular jurisdiction and make sure you're complying with all of those. Let's go to the next slide, please. So for the landlord, concerns are the rental loss insurance. Maybe there's coverage under the rental loss insurance policy that the landlord is supposed to carry under paragraph 8.3b. That is probably unlikely, but if you want to submit a claim, it doesn't hurt, doesn't cost anything. Those are usually triggered by direct physical damage to the property, not this kind of pandemic, but you should try to determine if the coverage helps, and if it doesn't, like I said, it doesn't hurt to submit a claim anyways. We should also talk about what's the impact of the coronavirus on landlords' maintenance obligations. There are many leases out there that require the landlord and it's to keep, for example, a shopping center in first-class condition or operate a first-class office building. The AIR CRE leases do not obligate the landlord to open or operate a shopping center or an office building. Rather, in paragraph 7.2, it requires the landlord to, quote, keep in good order, condition, and repair the various parts of the building, the physical parts of the building and the common areas. But there is no duty to open and operate a shopping center or an office building. But if a landlord voluntarily or prophylactically decides to close a shopping center or office building, then at that point, the landlord is on its own, because our leases in paragraph 38 have a covenant of quiet possession, which says basically as long as tenant pays rent, tenant will have quiet use and enjoyment of the premises. This is also a covenant that's implied by law, Civil Code 1927. It basically implies that a tenant shall have quiet enjoyment and possession. But this warranty is only against landlord's own acts, not against those of strangers. So if a landlord voluntarily decides to close a shopping center, then I believe that they have violated quiet possession, and they probably can expect to have a lot of the tenants ask for rent abatement under paragraph 38 or under Civil Code 1927 for quiet possession. So that's all the material I had. So I think that's we can ask some, if we have time, we can answer some questions, Tim.
Very good. Okay, and so I'm going to go through the questions, Brian, and if you've already covered them, then take them as best you can, or we can move on to the next one, because we have quite a few that came in through the chat box.
Okay.
So the first one says, please confirm that under clause 39 of the AR leases, if a tenant exercises an option to extend their lease, then stops paying rent, citing COVID-19 before the lease extension term commences, then the tenant loses the option to extend. Is that true?
It depends. Like we said earlier, first of all, to invoke paragraph 39.4, you have to decide which one of those you're going under, because some of them apply without notice. Like I said earlier, some of them require that notice be given. So carefully look at there's 4 options under paragraph 39.4A and 2 of them under 39.4B. So take a look at those provisions again, and I think the answer is you have to give a notice to be trying to terminate it. I would give notice if I was you. I would give notice to be on the safe side, because I believe that the tenant can make a good argument under 1511 that they got abatement. Go ahead.
Okay. And does the landlord need to notify the tenant that they're in default of the lease in order for the tenant to use that option?
Yeah, I think the safe thing for a landlord to do is, yes, go ahead and give the notice, so that at least the landlord can argue that I give them the opportunity to avoid losing the option. They could have elected to pay rent and avoid the loss of the option. And I think it may not be a bad idea to highlight to the tenant that this could be a potential consequence of their non-payment of rent. Now, that's not required, but I believe you're going to look more sympathetic to a judge or jury if that's what your argument is going to be, that I didn't try to sneak it up on the tenant. Rather, I told them this is a consequence. I'd like you to pay rent, not only because you owe it, but also I don't want you to lose your options.
Okay. And does the landlord have the right to find out if the tenant received PPP dollars and how much? And kind of a secondary question to that is, what prevents a tenant from receiving the PPP dollars and not paying rent?
Yeah, that's a good question. So I do not believe the landlord has the legal right to make the tenant provide those applications, because they have confidential financial information. There's nothing in the law that I've seen it that requires it. Obviously, if you're negotiating with a tenant for rent abatement, rent deferral, you're perfectly within your right to ask the tenant to provide that information to you, and then they've voluntarily given it to you in order to be able to qualify for the rent reduction, rent deferral. In our amendment that we prepared, we assumed that landlords have already been provided with these documents and they're satisfied that the tenant's business is adversely affected. And in our amendment, we provide that the tenant represents and warrants to the landlord that the tenant's business has been adversely affected and has suffered a diminution in income. And the information that the tenant did provide the landlord is true and correct in all material respects. So we did close the loop there. If you get the documents, the amendment covers you for the truth and accuracy.
Okay. Next question, if landlord defers rent for April, May, and June and amortizes over 12 months with payments beginning in July, can the landlord ask for interest on the deferred? And if the tenant does not pay its installment obligation as agreed, can landlord serve the 3-day notice?
So, okay, so let's break that. That's a two-parter. Let's break it down to the first one. Can you charge interest? I believe so. The lease already provides that you can charge interest. I did mention there are some municipalities like LA which prohibits charging interest. So you have to pay attention to make sure the law does not prohibit you from charging interest. I believe you can charge interest. The other part of the question, which is if the tenant doesn't pay, what happens? So the amendment that we prepared for the reduction rent deferral specifically provides that in order for the tenant to get the benefit of rent deferral or rent reduction, the tenant has to fully perform through the rest of the then remaining lease term. So the tenant has to perform the pay rent for the rest of the lease. If the tenant fails to pay rent, then the benefits that were negotiated go away. There's no more deferral, no more reduction. Of course, we go back to what I said earlier in the conversation today. 1511, Civil Code 1511 specifically says this law overrides the contract. And whether that's true with respect to an amendment signed in the middle of the coronavirus pandemic remains to be seen. We've done the best we can to get the waivers from the tenant to make sure that it's going to be enforced. Whether the courts will enforce it, notwithstanding 1511, is an open question and a good question.
Okay. Next question. Are the respective rights and obligations of the lessor and lessee different for a ground lease as compared to the more common lease for land and building?
So a ground lease is typically a very long-term lease of 55 to 99 years. And the rights and obligations of the parties under a ground lease are similar to what we call a space lease, the leases that we publish for the AIR CRE that you use. I do not believe that the legal rights and remedies are different, but ground leases are a very different animal. Ground leases are really not a two-party transaction. They're really a three-party transaction between a landlord, tenant, and a ground lender. The tenant will typically go to a lender and get a loan on the lease as collateral. In putting that loan in place, the landlord will agree to certain protections in favor of the lender. So the landlord will agree that before the landlord can terminate the lease, the landlord will not only give notice of default to the tenant, but it will also give a notice of default to the lender, who will also have its own separate notice and opportunity to cure. So while the rights and obligations under the law are not that different, the practical documentation is vastly different. You need to look at the documentation and the agreements between the landlord and the lender, because the lender will have its own separate cure rights, which are typically much longer than the statutory periods, because the lender loans money based on the ground lease being its collateral. The lender does not want to lose this collateral based on a short notice and opportunity to cure.
Okay, good. Can you please address the guarantee of lease and how it plays into the tenant not paying rent? Is it still a valid document? And if not complied with by the signatories, is it considered a default of the lease?
Yes, the answer is, so the guarantees are valid. If you've used AIR CRE guarantee forms, those are valid, and the guarantor is obligated to pay the rent that the tenant fails to pay. And it's a continuing guarantee that runs throughout the term of the lease. So as the landlord, you can sue the guarantor, notwithstanding that the tenant may have a moratorium on evictions. You can still sue the guarantor for payment of those rent that they guaranteed to pay. And that's a separate independent obligation of the tenant. The fact that there's a stay or there's a moratorium on evictions, does not negate or affect the guarantor's obligation to pay rent that's due under the lease.
Okay. Now going to the chat box. Have you heard anything from insurance industry or government to allow landlords to use the loss of business rents income, that's in quotes, in their insurance policy to cover vacancies?
I, like I said earlier, I do not believe that most rental loss insurance policies cover the landlord for the rent abatements that are occurring today. Because there is, those usually are triggered where there's events such as fire or something that has a direct physical impact on the property. So you really have to check your own particular coverage. I don't think so, but I don't know for sure. So you have to check the coverage, submit a claim, and that's the only way to be sure.
Okay, and just a quick comment. Obviously, we are past the 1 hour. It's a little bit after 12 now. Brian, if you have time, we'll keep going through. There's a lot of really good questions in the chat box. So anybody that wants to stay on and hear your answers, as long as you have time, we're good.
Yeah, I have time, and I'm sorry we started late because of the computer problems.
Okay, so paragraph 6 of the multi-tenant lease, AIR lease, says the tenant will not use the premises in an unlawful manner. Since it would be unlawful to open when a stay-at-home governmental order is in place, can a tenant claim a right not to pay rent on the impossibility of performance theory or something similar?
Yeah, that's a good argument. That's a so you can, the tenant will argue one part of the lease requires me to comply with laws, and that law requires me to close, and the other part requires me to pay rent. This all comes back to the same argument under 1511, where there's a government order that says you have to close, and the closure is causing you to lose money. So we don't know for sure the answer. The tenant's argument is there's no consideration, there's lack of consideration. I paid money to be able to use the space. I'm not able to use it, so I don't want to pay rent. And I believe that is a good way for a tenant to bolster its argument for rent abatement, because the lease specifically says, hey, you got to comply with laws. The law says I got to close. If I close, I can't pay rent. But the landlord's counter is, I gave you the space. I didn't guarantee that you can use it. So.
Okay, and you may have this one may be wrapped up in that last answer. Have there been any court decisions in the last few weeks addressing frustration of purpose, prevention of performance, or any similar arguments supporting tenant remedies?
Not that I'm aware of. The only case that I mentioned that I'm aware of is the one from Pennsylvania that I mentioned. You have to realize it takes a long time for the court process to work its way through before we get a published opinion. It takes years. So I'm just surprised how Pennsylvania was so quickly able to adjudicate and then publish an opinion. So I think it'll be a while before we get published opinions on these types of topics.
Okay, next one is a good question. It says, given the lack of specific force majeure language in the AIR CRE leases, if the courts deem the COVID-19 pandemic a relevant force majeure event, will landlords be exposed?
It depends on the particular force majeure provision. If there is one in the lease, like I said, typically force majeure provisions specifically say that the tenant still pays rent. I would be surprised if there's a force majeure provision that the landlord agreed to which abates rent. So fitting within the force majeure events doesn't necessarily get you rent free. So it's usually just postpones complying with your non-monetary obligations. And I think that's one of the issues that we have. A lot of people think of force majeure as being synonymous to rent abatement. Oh, I don't have to pay rent if there's force majeure. So you have to look at the specific lease provisions, and a lot of them say, no, you still pay rent.
Okay, and just give an example, Brian, of a non-monetary obligation.
So for example, to open and operate, that's a non-monetary obligation in shopping centers. To complete the construction of tenant improvements, if you're delayed because the city inspectors are not coming to the jobs on time, if there's shortage of materials or labor, that will postpone performance of if there's a due date for completing that construction, that gets postponed. If there's for example, in a shopping center, there's a co-tenancy provision which requires another tenant to be open for you to be open and operating. And if the other tenant closes, then that excuses you as well. But all those are dependent on the specific provisions.
Very good. Okay. Should leases signed post-COVID, so leases that are being signed from this point forward, should they include COVID-19 waivers? And if they are, if they have that, will they be enforceable?
Okay. I'd love to know the answer to that question, because I'm preparing a lot of amendments, both on behalf of landlords and tenants, where we're documenting these rent reductions, rent deferrals. And I, on behalf of the landlords, have the tenants waive Civil Code 1511 and all the defenses that I mentioned to you earlier. And I'm always, I think it will be up to the judges to decide how many times am I going to let a tenant go to the well, right? You come to the landlord and the landlord helps you out, reduces your rent, defers your rent, and then you still don't perform. You still use the same excuse. I think it's going to be more a question of equity in each case than strict contract interpretation. So we don't know the answer to that question.
Okay. This is a little bit of a longer question, but I'm going to read it all. I opened an escrow on a building in February, served a month-to-month tenant a 30-day notice to evict on February 17th, and ordered the landlord not to collect rent. It's been 2 months and the tenant hasn't vacated. All attorneys are telling us we can't evict the tenant due to the moratorium till at least September. Do you have advice on that?
You really need to check the local limitations and moratoriums. It's not one answer fits all. There are so many different layers of restrictions and moratoriums, federal, state, county, city, that you need to check it. Probably you're not going to be able to evict that tenant for a while, but you need to check the particular jurisdiction to see what the limitations are. No, don't forget, I also mentioned there are some tenants that are not exempt, that are not being covered. So the big companies that have multiple locations are publicly traded, you can evict them. The moratorium does not cover those tenants. So I assume it sounds like you have a mom and pop tenant.
And the next question is kind of a difficult one. Basically what they're asking, a couple people have asked, do you have any insight as to how the courts are, courts are already backlogged. How is this situation going to increase the volume of cases and lower the capacity of courts given social distancing and staffing cuts, et cetera? Have you talked to anybody in the courts that maybe has some feedback on what's going on in the courts and how this is going to delay things even further?
So the courts have continued pretty much all trials and proceedings, hearings, except for very, very emergency matters that you can go and ex parte. The courts are not open. So I think the courts are going to deal with criminal matters first. The second order priority will be family law, and the third order will be civil. So they have to deal with the backlog that's being built in the system right now. And once that backlog gets cleared, then you'll be able to get back to something normal. I don't think we're going to get anything back to normal. And normal for courts means a lot of delays anyways, right? So whatever is normal for the courts won't probably another year. It'll take a long time for all these cases. And you don't forget, you have a lot of new cases. All this is going to create a lot of litigation between landlords, tenants, buyers, sellers, and borrowers and lenders. So.
And do you see mediation as becoming a method that parties will start to rely on in order to stay out of the courts?
Yeah, mediation can be very helpful. I know the AIR is offering mediation. I think it's a very good tool for resolving disputes, especially now that we're going to have a longer backlog and delay in the courts. The issue with mediation is that the parties have to be ready to settle. And you can't go to mediation early if the parties are not ready. So yeah, absolutely, mediation is a wonderful tool for resolving. And I just did mediation via Zoom. It was fine. It was not as good as being there in person, but I think we made some progress. So I think we're going to see more mediations done by Zoom for the next few months still.
Okay. Should you still file a 3-day notice even though you can't enforce it right now?
Well, I think I covered that. I believe there are some strategic reasons to do it, but I believe at the end of the day, you're going to be hard pressed if your tenant is not if your tenant is subject to the moratorium. I think you're going to be hard pressed to get a judge to evict them when you file the eviction action during this moratorium, because a lot of judges are going to. And don't forget, unlawful detained judges are specialists. They see this day in, day out. That's all they see. So after a couple of weeks, they'll be more knowledgeable than any lawyer or tenant out there. And they'll have their approach figured out.
Okay, I have restaurant tenants that are considered essential businesses, but have voluntarily closed and are not trying to adapt to the to-go, food pickup market. How would you suggest this be handled?
From the landlord's perspective, I think the landlord has a good argument that this is not a governmental order that's prohibited you from operating. Rather, you chose not to operate because you felt it was not as profitable. So I think the tenant is going to have a hard time arguing that it closed due to operation of law when the law exempted that business from closure. And I think it's going to be a tough battle for the tenant. Now, what's happening in my experience is most people are trying to come to a practical resolution. They're negotiating in the shadow of the law, but I think most people understand that this is a historic event that has happened worldwide, and most people are trying to work something out, which I think is the prudent thing to do. Think about it. If you have 3, 4, 5, 6 months of rent in dispute, does that really make it worthwhile to go to court and spend a lot of money and legal effort in battling that amount of money? And then also consider the impact that it's going to have on the ongoing relationship between the parties. And if you have a landlord or a tenant who's very upset because of how they were treated during this downturn, it's gonna impact the parties' relationship long term.
Okay, and this good question came in. Oh, where'd it go? Where and how can I find my local jurisdiction ordinances? My properties are in Orange County in multiple cities.
I do not believe there is an easy answer. If you email me, there is a link that I can send you to go look. And I think it's a residential, but they do have the commercial information in there too. So email me afterwards, Brian@mashianlaw.com, BRYAN@MASHIANLAW.com. I'll send it to you.
Very good. Okay. Can AIR CRE provide us with a list of the specific documentation to request of tenants who have indicated they can't pay due to the hardship?
I think you have it already in the library. You have the tenant application, so you can have the tenant resubmit the application, and as if they were a new tenant, you would underwrite them the same way. Ask for the financial, ask for the diminution in sales before and after. I think, Tim, if you want to think about, maybe we can do something specifically for this purpose, but I think most of what you need is already in the library.
Right, and I don't know if maybe the person who asked that wasn't on, but we have published 2 new agreements in the last couple of weeks. One that is an amendment to the purchase, sale, and escrow agreement that lets you modify either the purchase, the sale, or the escrow based on what's going on now. And the other one is the base rent reduction deferral amendment that allows you to work with to serve your tenant or your owner, and getting the 2 of them together to agree on a new rent base and things like that based on what's going on. Okay, another question. I have a buyer wanting to terminate escrow and requesting refund of non-refundable deposits, citing a material change occurred. It's a multi-tenant park and most tenants have paid April rent. Thoughts?
Most tenants have paid April rent is where the rub is, because under 9.1N of the purchase and sale agreement, the tenant can cancel if there's a material adverse change in the property. And I believe the tenant's non-payment of rent will be considered a material adverse change. So it's a question of, when you say most of the tenants, is it most by number? Is it most by square footage? Or is it most by dollar amount? And that becomes a question of fact. What is material? So these kind of questions are difficult to answer because I don't know whether this person intended, the buyer intended to use it for investment purposes. Did they intend to remove the tenants and self-occupy it as the owner user? How long were the remaining term of the leases? Whether he's below or above market. So I think these are good questions, but I don't believe that we're able to give a one-size-fits-all answers. It depends on a lot of factors, some of which I just outlined to you.
Okay, another good question. If the the AR CRE leases stipulate how notices have to be delivered, whether it's U.S. Mail or UPS or FedEx, and so a tenant has vacated, he's not. So the lease says you have to deliver it to his place of business. He's not in there anymore. How do you deliver it?
Okay, so what you have is an abandonment. What the law calls abandonment is different than vacating. So under California Civil Code 1951.3, you can look it up. You could Google it, 1951.3. It's called abandonment. If the tenant is not in possession and hasn't paid rent for 15 days, you can give a notice of abandonment. You don't have to go through the unlawful detainer procedure. If that's the situation you have, you can serve the tenant, I believe, by certified mail. I'm going off my memory, but double check the statute. I believe you can serve them by certified mail at the premises and the last known addresses. And I think there's a statutory form for notice of belief of abandonment that you give the tenant, and you tell them, look, we believe you've abandoned the space, you haven't paid rent, and if we don't hear from you within a certain amount of time that's statutorily dictated, then we're going to go in and change the locks. So you can actually use the abandonment procedure, which I do not believe is affected by any of the moratoriums, only unlawful detainers.
Okay, two more questions and then we'll wrap up. First one is, can a lessor, what type of financial information can a lessor ask for with regard to tenants who are claiming they can't pay rent, and what rights does the landlord have in that regard?
So I believe you want to ask financial information to deal with two topics. One is the diminution in sales due to the COVID-19 closures. How much were your sales before and how much are your sales now, if any? And the second question is, how much money do you have? What are your assets? Do you have other resources to pay rent? So depending on the answers to those questions, you can decide whether or not you want to be deferring rent or reducing rent. The second part of the question was, what kind of, say the second part again, Tim?
Oh, shoot. But basically what they want to know is just what does the landlord have any rights to request their financials so that they can prove that the tenant is actually having hardship.
I do not know.
I guess the question is, Brian, obviously the landlord can ask for anything they want.
Exactly. That's it. What you ask for, to give them a consent.
Tenant obligated to give anything.
Right. No, they have to. It's a quid pro quo. Give me this so I can give you a rent reduction.
Okay. Okay, last question. Oh, you know what? A quick clarification. Can you please repeat what you said about Newsom's order and international businesses with more than 500 employees?
Sure. 1 second. Let me find. Okay, so this is Los Angeles Ordinance number 186585. It's dated March 27, 2020. It specifically excludes tenants who are, quote, multinational company, a publicly traded company, or a company that employs more than 500 employees from receiving the benefits of the unlawful detainer moratorium.
Okay, good. Okay, I think, Brian, that's going to wrap it up. If you have any final comments, speak now. Otherwise, we'll wrap up. Thank you for being on. Keep in mind, as I've mentioned a couple times, we will post this to the website. We'll do our best to get it out over the weekend, but it's more likely that we'll get it out on Monday. We will send an email to everybody once that is posted to our website. As I mentioned earlier, the 2 previous town halls are also on the website. So you can go to our AIR CRE, click the education tab, and you'll see those. And then Brian's will be up there either over the weekend or on Monday. As I mentioned, next week, we're going to be doing one on, I believe it'll be on generating business, even in a COVID-19 environment. And then in 2 weeks, we will have a speaker from Gensler speaking about how architecture of spaces is going to change based on everything that's gone on over the past few months. So thanks again, everybody. We will be in touch, and have a nice weekend.
Bye-bye.